This gets into the dynamics of everything with Lafayette County and the state of Mississippi, the actual pure negligence, the culpable negligence, and the recklessness of everything. The Fourth Amendment, incorporated to apply to the states through the 14th Amendment, Baker v. McCollum, protects individuals against unreasonable seizures. U.S. Constitution, Amendment 4. Because they involve unreasonable seizures, constitutional claims for false arrest against state public officials arise under the Fourth Amendment. See Carter v. Butts County. An arrest is a seizure. Claims of overdetention under 1983, 42 U.S. Code 1983. Claims of overdetention can arise under the Fourth Amendment's right to be free from detention without probable cause, or under the 14th Amendment's substantive due process right to be free from continued detention after it should have been known that the detainee was entitled to release. See at 952, also see Canning v. Macon County. Proving a violation requires a plaintiff to establish that the defendant was deliberately indifferent to his due process rights. I think I've proven that there's been a deliberate indifference since day one. To satisfy that standard, a plaintiff must show three things. One, the defendant's subjective knowledge of a risk of serious harm in the form of continued detention even after the plaintiff had a right to be released. Two, disregard of that risk. And three, disregard by conduct that is more than mere negligence. Failure to take any steps to properly investigate and identify the claims made on affidavit to be grotesquely false in nature is sufficient to raise a question of fact as to his deliberate indifference towards Reardon's due process rights. Numerous courts have also reached the almost tautological conclusion that an individual in custody has a constitutional right to be released from confinement after it was or should have been known that the detainee was entitled to release. This is their job. They're supposed to know this, especially when it comes to the liberties and the freedoms of assumably innocent American citizens. Depending on what procedures the state affords mere detention pursuant to a valid warrant, but in the face of repeated protest of innocence, will, after the lapse of a certain amount of time, deprive the accused of liberty without due process of law. A refusal to legislate equally for the protection of all would unquestionably be a denial of equal protection. This conceded, upon what ground can it be pretended that a refusal to execute or a failure to do so through inability, equally with reference to all persons, is not also a denial? I maintain, therefore, that the true meaning of this constitutional provision is that the state shall afford equal protection to all persons within its jurisdiction. Failing to do this, whether that failure is the result of inaction or inability on the part of the one or the other of the coordinate branches of the state government, the remedy lies with Congress. Whenever it appears that any state has failed to discharge this high constitutional obligation to all its citizens, it is not only within the power, but it is the solemn duty of Congress to enforce the protection which the state withholds.
Hello?
Hi, is this Matt Reardon?
This is.
Hi, Matt. This is Rachel Alcorn. I was on the other line, and I thought that might have been you calling in, so I apologize. I'm just giving you a call back.
Okay. Trying to.
What can I...
Well, I'm completely, to be completely honest with you, I wasn't going to speak with you, Rachel, because I'm trying to figure out, honestly, what what can drive somebody to make the claims that you made on this affidavit? And we've never met. I spoke to Jerry Madden earlier. He didn't speak with you. And it's a coincidence that, the second time, for the second time in a year's time, I'm sure I'm in the Supreme Court. I'm fighting a tremendous injustice from 2017, and for the second time in a year's time, the assigned judge on two separate circuit court matters was changed in the system. I never was out of line. I never threatened anybody. I did what I would feel would be the civic duty of anybody. Should be any concerned citizen, and I was in particular involved in this because of it being my case. And the next day I get this affidavit taken out that I've pulled all the records from Chancery Court. The factual description here on this uniform commitment affidavit is far from the truth.
Well, let me explain to you why the affidavit was filed in my position here. So I supervise the Assisted Outpatient Treatment Team and the I-Court team, which are two programs that are responsible for providing and supervising the treatment for people who are on outpatient commitment orders. And you were on an outpatient commitment order out of Calhoun County, and the I-Court team and the AOT team both tried to engage you. Let's see, I believe that was from about your release in June to September.
Nobody had contacted me or anything.
Yes, they did, and we have documentation of that. So,
what number?
In September, our executive director issued a letter to the Chancery clerk of Calhoun County saying that you're on an outpatient commitment order through July 22nd of 2021, and we have not been able to engage you, and that we would not reattempt to engage you to provide services unless you reach out to us or at the request of law enforcement and or the Chancery Court to provide mobile crisis team support. So, at the request of local law enforcement, then we were engaged by them about the concerning behavior of you at the court. And so, within my role, I filed an affidavit of commitment, which started the process, which is a legal process in the state of Mississippi, and then we followed that process through.
Okay. So, I figured it had come from Joey East. I'm not asking you to familiarize yourself with everything that I've had going on. God knows that it's been a tremendous amount. But to actually take somebody such as Joey East, just right there, this word to not look into anything, I think is highly prejudicial for one. You actually knew there are major issues that are actually involved.
If you weren't already, I'm sorry, this doesn't really have anything to do with your court case, and I'm not familiar with that. But you are on an outpatient commitment order for us to provide treatment, and that's really the only issue that I have. If you were already engaged in treatment and we were able to provide treatment and provide that court ordered monitoring, then we would have more information.
But going into public places and recording people is not for one, I'm a credentialed member of the press. Lafayette County multiple times has gotten a copy of my press credentials, so I'm documenting. Records were fraudulently changed in circuit court. There's no way that I was delusional and made that up when it's actually truly documented. Were you sent the email that I sent Jerry Madden with the link that actually shows that completely documented?
I don't believe so.
It's unfair to call me delusional when I've gone above and beyond to publish, to produce the proof, and this is why I do that, is so that I'm not called crazy, so that I have evidence backing up what I'm saying, And I mean, to be completely honest with you, to call me delusional, and to not look at the actual facts and the published proof right there, makes me think that the person calling me delusional is delusional. Because you can't, I mean, the facts speak for themselves. The evidence speaks for itself. I'm producing a documentary. I've uncovered shocking things. And yes, I'll admit, they are some of the most bizarre, just uncharted, shocking things that it would be so easy to call me crazy. Had I not have had undoubtable, just there's indisputable proof of it. The county is trying to cover up what they did back in 2017. It's no surprise. Joey East does not want me around here. But what I'm doing is not illegal. I mean, granted, if I was a county official that had my hands tied in things that didn't really shed the best of light from a legality standpoint, I probably wouldn't want the person around either. But the fact of the matter is, not only am I a private citizen, but I'm a credentialed member of the press. Pressing in a non-threatening way to try to find out where the buck stopped, where the responsibility fell, and the next day, the day after, I get hauled in on a judicial commitment right in front of my own family and taken away for 2.5 weeks. I'm sorry. That is dangerous, and it chills the constitutional rights of other citizens.
Matt, I really want you to understand that you're on an outpatient commitment order, which that order requires that you participate in mental health treatment. And that we had already filed an affidavit of non-compliance and notified the courts that you were not in compliance with treatment.
Okay.
So that in itself would be enough for you to have your OPC revoked and go back to state hospital.
But to say that I'm paranoid and delusional and provoking people with my minor child, where did that come? Where did provoking people with his minor child come from?
That was information reported by law enforcement and community members who witnessed it.
You know, there's been one time that I've had my stepdaughter with me at Justice Court whenever I literally was getting some aerial video of the flag. She wanted me to fly the drone. The drone had a mishap and hit the ground. It was a complete overreaction by Lafayette County Sheriff's Department that brought 10 officers up there. I have done a public record request to get the body camera and officer statements of each of them. So if you can get that, good on you. They decided they were going to they made up their own investigation, even though it's out of their jurisdiction, to not have to comply with the public record request. That is sat open since the end of September. I was the most responsible person with my stepdaughter. In fact, you know, it's very sad. I've gone above and beyond to try to teach my children to not fear law enforcement. And that not all of them are, that just like anything in life, there's a few bad apples that can hurt the others, but to not fear them. You know, the first question out of her mouth whenever they pulled up was, "Mr. Matt, are they going to shoot you?" No child should ever be. That should never come out of the mouth of any child. And the fact that you know, I have literally gone above and beyond for my kids to try to provide a safe environment. There was nothing that I did that was, and that's all on video. In fact, that's on my website. That whole entire experience that you know I'm referring to, it's on video. It cannot be disputed. In fact, I was trying to get the additional stuff that they won't comply with. I mean, I'm not provoking people with my minor child. That's hearsay. To put that on an affidavit, and you don't even know me. Yet you didn't look into the facts, but you said that I was provoking people with my minor child. going into public places, recording people paranoid and delusional, but a paranoid and delusional person would not, corroborate the claims that they were making, backing it up with proof.
Matt, let me explain this to you. I filed the affidavit based on being the supervisor of the programs that supervise the outpatient commitment orders, which you had not participated in treatment. We had made multiple attempts and notified the court. And then I was provided information from law enforcement and community members about your behavior in the courts and that whole time period. And then after I filed the affidavit, then a certified pre-evaluation screener has to come and do an assessment with you and make a recommendation if they think you need to go to the hospital or not. And then after that person, then 2 doctors do an assessment and agree. So I'm only one piece in this. So it was not just me. It was me and then 3 other credentialed professionals.
But they were hired by the same county that deprived me of all my rights and what I've alleged to have been a election scandal back in 2017. It's under a civil rights investigation. Do you not think that Chancery Court, the same county, that it would be in their best interest to pick and choose who it was that was assigned as my quote-unquote representation and who was assigned as the quote-unquote special master and who was assigned as the doctor and the nurse practitioner? Because, I'm here to tell you, I've got all that on paper. Even what they were paid. It was...
I see your concerns. I do. And I wish that you had participated in your mental health treatment so that we had some history to back you up. But we don't have anything because you would never participate in treatment. So we don't have any documentation showing, hey, this guy is doing great. He is taking medication that's prescribed, or he doesn't need medication. He's participating in therapy. He's making progress in therapy. We don't have any of that because you've avoided the 2 different treatment treatments that I've tried to be able to engage you. So that would have helped you. But since you're on an outpatient commitment order and we haven't been able to engage you, we don't have any of that information to say how you're doing.
But do you understand why I would have trust issues, and particularly now why I would have trust issues with your organization?
I did hear what you're saying. I do.
I mean, I
certainly feel that way because we really just want to provide mental health treatment. Like I said, I don't know anything about your court case, and I don't want to. I intentionally stay out of stuff like that because I want to be able to provide, just mental health treatment. I want to meet the mental health needs of our clients. I don't want to get involved.
But this just created issues. It just, it honest to God, it created issues because I was not off the rocker crazy. I was simply, I'm an investigative reporter. I'm a credentialed member of the press. I'm having to go and do all the work of an attorney on my own case. I mean, it's very stressful. And to find a judge getting changed in the system twice over the past year and to simply want to know who would be responsible for this? How could this happen? All that. I mean, I never once I even told Jeff Busby, the circuit clerk, I'm not trying to blame your office. I don't think it was anything to do with your office. I just need to find out, where this could have happened. And, I mean, he got highly defensive. Contacted the sheriff. The sheriff blocked me in, told me not to go back into circuit court when I never threatened anybody. I mean, I record. That's the reason why I recorded, is because I'm tired of the lies getting spread. I have to have a way of justifying, of backing myself up and proving. Lafayette County taught that to me back in 2017 with the lies that they spread. And so that's the reason why I record, and I keep a recorder on me all the time, is because, you know what? I'm tired of getting lied on, just the lies getting spread. I have to. I feel the need, and sorry, nobody should ever have to feel that way. That they have to literally all the time, to protect themselves, to be able to prove and show this and say, hey, look, this is what really happened. Nobody should ever have to feel that way. But, it's the unfortunate, position that I find myself in, and this is a prime example why.
go forward. And also, I want you to know that we're not a county agency. So I think sometimes that's confusing for the general public that they think that we are a county agency, and we're not. All of our programs are certified through the State Department of Mental Health. So we're not a county agency. So like I said, we really do try to stay separate.
You know, I would love not to have any issues with you or your company. I certainly feel screwed over in the ordeal. I lost 2.5 weeks of time, and getting taken in front of my own family for something. My wife, I mean, like, she knows the truth. Like, she sees the evidence. It's on my website. I've gone above and beyond to make sure that I publish it, just to make sure that I can keep myself safe and protected. So I'm not labeled as crazy. And the county just immediately did a NCIS or NCIC report or whatever and I have good reason to believe that the reason for that is because everything's going to reverse in the Supreme Court from 2017. I've carried around a fake label of felon and stalker that the state of Mississippi and Lafayette County have known all along that I was innocent of. They charged me of a crime that literally was an impossibility for me to have committed. I had a bill of sale proving that. But they kept me deprived of all procedural due process rights for 6 weeks' time with a bond of $150,000, making sure that I couldn't get out on bond. I pled out to a crime I never committed because I had a minor child that was in Chancery Court unfairly. I needed to get her out. I sold my soul to the devil by pleading out to a crime that literally was an impossibility to have committed. It's going to reverse in the Supreme Court. Lafayette County knows that there's a tremendous dark cloud over its head. And I honestly, in looking at the papers and seeing the immediate NCIC report that was reported to bar me from any kind of firearm purchase, it just further goes to show the intentions, the foul intentions of these county officials. They can't admit that they were wrong on anything. They want to continue absconding with the things that they've done and really truly harming an innocent person that was innocent since day one. It's literally been fighting for his life. They have tremendously harmed my kids from what they've done to me. I've lost 4 houses over the last 4 years, and I'm doing everything I can to stay afloat and to overturn this injustice. So, I was thinking about this, and I don't want to have to, if it was Joey, and it's not the first time, it's certainly not the second time that he's done this sort of thing. Any type of information that you were passed, I would be willing to indemnify, completely Communicare and you, if I can get all the information that was passed to you by Joey. So I can hold, by Lafayette County Sheriff's Department, so I can hold the proper ones accountable that need to be held accountable.
That information is on the affidavit. The information that I reported to the Chancery Court, that's listed on the affidavit as to what the concerns were. And again, it's also, the situation was elevated because you were already on an outpatient commitment order and had been non-compliant with treatment. And because there was a history of concern, these new behaviors being reported definitely elevated the risk. And so that's why I filed the affidavit. And any information is listed on that affidavit.
I mean, did he send this to you via email? Did he communicate it via phone? How was this information relayed to you?
It was just told to me.
It was just told to you. I mean, he came up there in person or what?
This isn't about that. I mean, we followed the legal process of filing an affidavit.
Because you were given that information by law enforcement. But I would like to know how he reached out, and communicated this in exactly what Joey said.
I don't have have those words verbatim, but you can look back and reference as that affidavit.
Okay. All right. Well, I want you to know that, I mean, like, I don't want this to happen again. I mean, it's so unfair. I mean, I understand that, you know, I hadn't followed up with appointments, but I was also advised that there was a cost. And honestly, when I've lost 4 houses over the last 4 years and having to fight this tremendous injustice and having ongoing, you know, appeals in the Supreme Court, not having an attorney and having to fight these battles on my own, and literally, you know, it cash strapping my family down to next to nothing. I mean, there's legitimate reason for.
But the AOT team and the I-Court team both notified you that there would not be charges for your services. That's why we really wanted to provide you either one of those specific programs, and we did offer you 2 different options with multiple staff trying to contact you.
But my wife and I lost our house over there in Bruce, is what I'm saying. I never got notified of any of that stuff. We had lost our house in Bruce, and we had no other choice but to relocate to Lafayette County. None of that was ever communicated to me or passed along to me. That was house number 4 that we lost.
I mean, I know that we had multiple conversations with both of my treatment teams, and different staff members who were trying to engage you in various ways. And one of the CSS, you know, he showed me text messages that he'd exchanged with you.
Oh yeah,
I know that there is
the one that kept wanting to come out to the house. I mean, that kept making things sound so weird. Yeah, I mean that was very sketchy to me.
Well, again, I mean, you're talking about having difficulties coming to appointments, and that's the purpose of these programs, is trying to we want to, you know, eliminate the barriers. If you can't afford it, if you don't have transportation, you can't get there, scheduling issues, that's what these programs
are. But no, I didn't have issues making it to the appointment. It was paying for the appointment. Nobody ever, you know, relayed that, you know, all this was going to be cost-free going forward. There was the talk about it possibly, about there possibly being grants out there. But the fact of somebody that kept trying to push himself onto, you know, coming to my house, I have I've already got trust issues with you know, things that have gone on, and especially I had a guardian ad litem, you know, issue from family court.
I understand that. Let me tell you something, though. I hate to interrupt you, but I really want to get to the moving forward point. I understand what you're saying, but if you wanted to comply with your court order, you would have figured the situation out. I mean, you had several people calling you, and I know that at one point it was kind of bordering on badgering you. But again, my staff have a responsibility to help people uphold these court orders, and so that's why I know they were calling you so much. So if you really wanted to comply with the court order, you would have figured that part out. You would have made yourself more available. So you still are on a court order. In fact, when you released from Tupelo, CSU, I think on December 22nd, they have reissued a new outpatient commitment order. So that means that you're still on a court order. I don't have that yet. They were supposed to fax it over, and we haven't received it. I think it's just because of the holiday and staff being out at Tupelo CSU. So we should be getting that information as soon as possible. So we need to set up a appointment going forward.
All right. Well, I'm trying to. I had to get this thing addressed right here. I mean, like, this is. Put yourself in my shoes. I mean, it's hard to do that. For anybody, it would be nearly impossible to actually truly understand the David versus Goliath battle that I've had to endure. Like the stress has been overwhelming. I've done everything that I can do to literally, when nobody would help me, to step up and do the job of attorneys, because I couldn't afford to let this go by the wayside and get time barred out. My children deserve better. And That's why I got the press credentials. That's why I got the documentary. I got the website. I have literally tried to go above and beyond in proving my innocence, and I've done that. I've shown extreme foul conduct, misconduct on behalf of county officials that are trying to abscond with their prior immoral and wrongful deeds that they know. I think I've handled things in a very, considering the circumstances, to literally have had to carry to have lost everything, to have had everything going, to have been on the agenda to speak out and address City Hall on the day of the election of the Oxford mayor, to have been charged with a crime that literally was an impossibility to have committed, the same day that Joey East sends an email out to the mayor and the board of aldermen seeking to change 2 city laws regarding the carrying of firearms, all because I did a constitutional display, never threatened anybody the day before. I was on the agenda to speak out at City Hall the day of Robin's election, right after Joey. They pushed through those 2 city law changes while I was in jail without so much as the consent or the knowledge of the governed. I'm a Marine Corps veteran. The things that they've done are beyond criminal. And I felt that, I'm sorry for giving you all this information. You and Joey may be, buddies or next door neighbors, who knows? But, at the end of the day, the facts are the facts. I never deserved any of this. All I've been out for since day one is to protect and preserve the constitutional rights, my constitutional rights, and the constitutional and civil rights of others. I've taken politics out. It's no longer anything political. It's about right or wrong. And what they're doing is wrong.
Well, I just want to help you get mental health treatment. I mean, it sounds like you're going through a whole lot. I think it'd be a great idea for anybody to talk to a therapist, but it sounds like you've had an awful lot of hardship. And like I said, I'm really not familiar with all of this stuff that you have going on.
Well, but this could have been handled, and they didn't have to go to the extreme route, and I see that based on the paperwork that they could have chosen lesser routes. They didn't have to go straight to inpatient.
But you were already on an outpatient commitment order. That's the thing. When you're on an outpatient commitment order, you have to participate in treatment, or you have to go to the hospital. So if you had participated in outpatient treatment, you could have prevented that from happening, because we really don't want you to go to the hospital. That's the goal of these programs, is to keep you out of the hospital. But if we can't find you and we make all these attempts and we notify the court, and then we're notified by law enforcement and other community members that your behavior is bizarre, and you're going to court and interviewing people and disrupting, public places of business, then it elevates the situation to where, okay, well, we've got to revoke the OPC, and then this process has to start.
But that's the thing. I never disrupted their business. I never threatened anybody. I never posed any kind of harm to myself or others, as it was marked. I literally, it's a court. It's a circuit court that I had matters filed in. So to say that I was disrupting their business is now saying, okay, it's not really a court. It's it's a de facto corporation. It's not operating as an actual court. And that was what I found was odd about. I think
you're missing my words now. And we're getting really off topic, because again, I'm only concerned about your mental health treatment and the OPC. So I've told you that you're on an OPC going forward. And so will you please participate in treatment this time, because we would really love to be able to provide treatment that you need, and maybe this whole situation could be prevented in the future.
Yeah, I just want an understanding that some of these things, that I'm not a delusional person. I'm not a, it would be one thing if I didn't back it up with evidence. And that's why I said, I mean, if you're going to call me delusional, at least, familiarize yourself with what all's going on and look at the evidence to see that I'm not.
So we'd like to get you set up with Susan Beard, who is one of our therapists here, for an appointment. Of course, you would not have to pay anything for the record. You would not have to pay anything. There would be no charge for your services. If you're prescribed medication, you would have to pay some for your medications, but we have a pharmacy that we work with, and we try to make them as affordable as possible. And I don't know that you were taking medication in the past. I don't know that off the top of my head. I would have to review your chart, so I'm not sure that would even be an issue. But you do have to participate in treatment in order to comply with the outpatient commitment order. So I'd like for you to set up an appointment with Susan Beard sometime next week.
Okay. Can I call back and set that up?
You can, but I do want to say that this is what was happening before when the AOT and I-Court teams would try to schedule with you, is that just kind of beat around the bush a little bit, and then when it came to actually setting an appointment, that wouldn't happen. So that's why you were in non-compliance. And again, we don't want you to go to the hospital. We would love to say you have been participating in treatment, you've been making progress. We would love to be able to provide that feedback about your court order so that in a year when it's up, we can say, no, he doesn't need this court order anymore. He's good to go. He's completed all of his treatment. So that part's on you. We can do a lot to bring it to you, but you have got to buy into it. So are you going to call back next week to schedule an appointment with Susan?
I will. Like I said, there are a lot of things that I find particularly wrong about this whole situation, and we can agree to disagree on that. But the fact of the matter is, I may not have gone to schedule, or I may not have scheduled appointments, but the fact is, it was lies that were told to y'all by local law enforcement that got y'all back involved and literally stripped me of my freedom and liberty.
No, you were already on an OTC, so we were already involved because you're on outpatient commitment order. She's got a 10 o'clock appointment available for next Thursday, which is the 6th. Will that work?
You can schedule it for that. I know that my wife is pregnant. We've got appointments, and it made it extremely hard for her whenever all this stuff happens. But I know you said I was on an OPC, but you also said that y'all had turned in a notice saying that y'all were going to back off, or y'all weren't going to reach out anymore. Therefore, I mean, I don't.
They reissued it after this hospitalization, which is common practice. They do that a lot.
Right. This hospitalization I'm saying this hospitalization shouldn't have happened, and it's the direct fault of Lafayette County Sheriff's Department.
Well, Matt, I would love for you to move forward with your treatment so that you can say, look, I'm doing everything that I need to do. So I'm going to put you down for this appointment at 10 o'clock on Thursday, which is the 6th, with Susan Beard. And that's going to be at our main office location on Highway 7. Do you know where we're located?
I do.
Okay. That's here in Oxford. It's the Oxford location. Is that okay?
Yeah.
Okay. If that appointment does not work, or you need it to change, please call Susan, or you can call me. But I really want to try to get you communicating with Susan, since she's going to be your therapist, to change that. But again, I really want to encourage you to stick to this appointment. And if this appointment time doesn't work, you really need to reschedule that ahead of time because, again, you're on this court order to participate in treatment.
Okay. All right. Sounds good.
Okay.
All right.
Well, thank you, Matt.
Thank you, Rachel.
Have a good day.
You too. Bye.
Bye-bye.
Hello, this is Sandy Rogers.
Hello, is this Communicare?
Yes, it is.
Okay. I needed to, I have an appointment tomorrow. I need to reschedule that for next week.
Okay, I'm not sure how you got me. I'm the executive director. So which office are you seeing? Or what provider are you seeing?
Beard. Susan Beard, I think.
Hello, this is Sandy Rogers.
Hey, Sandy. I had a missed call from this number. I was calling back Matt Reardon.
Yes, sir. I left you a message. Miss Beard has left for the day, and she will call you first thing in the morning. I will let her know what the call's about, but she will know that your appointment for tomorrow is canceled, and she'll call you back in the morning to reschedule.
Okay, yeah, my wife has got a baby doctor appointment in Tupelo. We're down to one vehicle, so we're out to Tupelo first thing in the morning.
I'll let her call you. Okay.
All right, thank you.
Right.
Communicare. Yes, ma'am. I need to speak with the, who is the executive director up there?
The executive director is Dr. Sandy Rogers.
Is she in?
I believe she is. I am looking for her extension now, and I will forward you.
Okay,
May I ask who's calling?
This is Matt Reardon.
Okay, I will. Now, Matt, this is Susan. Are you trying to schedule an appointment?
No, not right now, Susan. I need to get the if Stacy waits. There's now two huge flaws and inconsistencies. Actually, just quite frankly, really unlawful things that have transpired over this set of events. Stacy Waits knows that she gave false information on her intake. If she had a recorder, I am requesting and demanding that all of that be preserved to verify for accuracy. I know that stuff that she put in her report was extremely flawed. Some of it was the case, but some of it was just far out there. And so I want to fact check that.
Okay, I'm going to put you on hold for just a moment and see if Dr. Rogers is available. Just a moment.
Okay.
Actually closed, and she's got a sign on it saying that she's in a meeting. So would you like me to take the message down?
Yeah, if you can just have her give me a call. I was told, I wasn't sure 100%, who Stacy was, if she was contracted out, to to another party, or if she was an employee of Communicare. I was informed just a little while ago that she was a employee of Communicare, because I'm getting the audio from the hearing in front of where I was confined, and the other piece that I'm needing is I would like to get anything recorded with the doctor and nurse practitioner. I would imagine that they recorded it on their end, as well as Stacy Waits. This was ludicrous. It was the most just despicable thing I've ever imagined.
Okay, well, I will leave this message for her, and hopefully she'll be able to call you back. I can't make a promise.
Dear Dr. Rogers, between the date of December 6, 2021 and December 7, 2021, an employee of Communicare by the name of Rachel Alcorn came in receipt of inaccurate, untrue, and defamatory information given to her by Lafayette County Sheriff's Department, which she acknowledged had been sourced by the Lafayette County Sheriff Joey East himself. This in turn set off a series of events to follow, which in turn brought about irreparable injury while hindering the due course of justice, and as a result, broadened the scope of all which currently transpires. In the interest of transparency into all of this, I'd like to make it known that this entire fiasco was created based upon the fact that for the second time in approximately 1 year's time, I had discovered an important record that was fraudulently altered in Lafayette County Circuit Court. Finding out how this record could have been changed and who could have been responsible for changing it was and still is two very important questions to me, as the same thing has happened now on both currently open filed matters of mine in Lafayette County Circuit Court. To make matters even worse, I've identified numerous pieces of inaccurate information reported by another employee of Communicare by the name of Stacy Waits, whom conducted the intake at the Lafayette County Detention Center on December 8, 2021. Then there's the absolute bizarre notation and reasoning by the doctor and nurse practitioner via remote video conference, which when combined with the other facts and all other erroneous and obnoxious matters at hand, lead me to believing that everything that transpired was the result of heavily politicized persecution for me having the drive and focus that I have on all current ongoing legal matters I am involved in. Particularly when this doctor notated on this report that I was very preoccupied with ongoing legal cases and described my condition as bipolar with delusions in his report, recommending inpatient commitment. To fault me for being preoccupied with ongoing legal cases is absolutely ludicrous when factoring in that I'm having to perform the work of an attorney due to not being able to afford the monumental cost an attorney would charge to represent me in 2 Supreme Court appeals, 2 Circuit Court matters, a Chancery Court matter, a recently wrapped up Justice Court matter, and at a bare minimum now 1 pending District Court matter. Being preoccupied with ongoing legal cases should be fully expected of anyone currently engaged in multiple legal battles in multiple venues such as I am, particularly when that individual happens to be representing himself and seeking full vindication from a complete miscarriage of justice that transpired in 2017, which continues to be exacerbated through continued lies tendered by Lafayette County officials and in particular Sheriff East, whom in fact played a hand in all that has occurred dating back to May of 2017. Contrary to the opinion of this doctor and your staff, whom never fact-checked anything, the claims I have made and produced a plethora of evidence supporting are not conspiracy theories or delusions, nor have I ever provoked anyone with my minor child, as the affidavit and reports following attested to. These are insinuations and character assassinations that Lafayette County, and in particular its sheriff, wanted to have conveyed, which at least temporarily it was successful in doing, through full exploitation of the state of Mississippi's mental health laws and through the assistance of your employees and contractors working on behalf of your organization at the expense of my rights and liberties.
the negligent acts of your employees have sought to demonize lawful, authorized, and constitutionally protected activity through pushing a narrative that was distasteful and untrue. I am an independent, credentialed member of the press whom has taken on a role of investigating and reporting the corrupt acts demonstrated by this county while fully documenting my journey and seeking full vindication. And my credentials have been on file with the county and sheriff's department, so this was no new occurrence or surprise. For your convenience, I'm attaching a copy to this letter so that they again are on file in one more place in this county. The most unfortunate consequence, however, is that employees of Communicare, through not properly following policy and procedure as it relates to state and federal law, have now directly aided and provided assistance to certain Lafayette County officials, and in particular Sheriff East, in their attempt to cover up and abscond from their wrongful deeds. As a result of such, I've lost all trust in your organization and its staff, and honestly, who could blame me? The state of Mississippi's mental health laws are outdated, and I firmly believe that what has transpired here demonstrates the level of ease for the state and county governments to exploit their own system, and through doing so, have done a pristine job of exposing its major flaws in the process. The procedure for initiating civil commitment proceedings is detailed out in Mississippi Code 412165, in that it states, if any person is alleged to be in need of treatment, any relative of the person or any interested person may make an affidavit of that fact, and shall file the uniform civil commitment affidavit with the clerk of the Chancery Court of the county in which the person alleged is in need of treatment. But the chancellor or duly appointed special master may, in his or her discretion, hear the matter in the county in which the person may be found. The affidavit shall set forth the name and address the proposed patient's nearest relatives and whether the proposed patient resides or has visitation rights with any minor children. If known, the affidavit must contain factual descriptions of the proposed patient's recent behavior, including a description of the behavior where it occurred and over what period of time it occurred. If known, each factual allegation may be supported by observations of witnesses named in the affidavit. The requirements in this simply were not met, nor were they ever justified. Not only was the affidavit not supported by any named witnesses, but the entire procedure was botched by the affiant attesting under sworn affidavit to non-factual claims, with claims that were in fact constitutionally protected and ordained, particularly for an independent credentialed member of the press in the performance of his duties, which Lafayette County, through its officials, nor employees of Communicare had any right to interfere with and hinder further. The affidavit and reports to follow were comprised of judgmental and conclusory statements that were untrue in nature and relied primarily upon information stemming from an outside party whom was never named as required under the above statute. Fortunately, in one measure of good faith, there's a listed imposition of penalties against false affidavits being filed in bad faith for a malicious purpose, in that the prohibition against charging the affiant other fees, expenses, or costs shall not preclude the imposition of monetary criminal penalties under Section 4121-107, or any other criminal statute, or the imposition of monetary penalties for contempt if the affiant is found to have filed an intentionally false affidavit or filed the affidavit in bad faith for a malicious purpose. A state law cannot be held constitutional if it directly infringes on established law on a federal level, to include if that particular law/legislation deprives a citizen of any constitutional right or any guaranteed due process right, to include substantive, in that a citizen is subjected to the undue deprivation of life, liberty, or property. A finding of mental illness alone cannot justify a state's locking a person up against his will and keeping him indefinitely in simple custodial confinement. Assuming that term can be given a reasonably precise content and that the mentally ill can be identified with reasonable accuracy, there is still no constitutional basis for confining such persons involuntarily if they are dangerous to no one and can live safely in freedom. The matter at hand was decided upon in Davidson v. O'Connor, a landmark U.S. Supreme Court case, which stated in short, a state cannot constitutionally confine without more a non-dangerous individual who is capable of surviving safely in freedom by himself or with the help of willing and responsible family members or friends. The question was then posed, may the state fence in the harmless mentally ill solely to save its citizens from exposure to those whose ways are different? One might ask if the state, to avoid public unease, could incarcerate all who are physically unattractive or socially eccentric. Mere public intolerance or animosity cannot constitutionally justify the deprivation of a person's physical liberty. See Cohen v. California, 403 U.S. 1524-26. In conclusion, the flaws which have occurred in this matter have not only violated the mental health laws of the state of Mississippi, but have created a material breach of substantive due process rights guaranteed to all citizens and protected under federal law. As such, you are hereby requested to review and revise your current policies within the following 7 days in order to bring them into compliance with not only state law but federal law, in order to circumvent a similar matter from occurring in the future and to provide in writing any offered changes to such policies. In addition, as stated above, please take appropriate action to produce and preserve any and all information associated with the incident below, to include any information describing the incident below that is maintained by Communicare and or any of its employees, to include any individual subcontracted out. This preservation should also include all audio recordings taken during intake, documentation notes taken, any communication regarding the matter sent and or received leading up to including the final determination being made to involuntarily commit Matthew Reardon to a state hospital facility on December 9, 2021. My best regards, Matthew Reardon.
This is Matt Reardon. I wanted to document this live on Facebook. For the second time, Lafayette County Sheriff's Department pulls into my driveway with another mental writ, apparently this time signed by Communicare, again, after the first fraudulent commitment that happened December 6th, or December 7th, which stemmed directly from me finding Lafayette County Circuit Court fraudulently changing records for the second time in a year, based on lies, pure lies, that stem from the Lafayette County Sheriff Joey East. The most ridiculous of lies. My wife just got out of the hospital, and we can't even live in peace without constant harassment. This would clearly be the other one, probably.
That's going to be my son. He's the one that's got the vehicle.
Look at this. Facebook Live. They pull into the driveway, light it up with blue lights, wake up the dogs, wake up the kids. Somebody has got to put a stop to this. This is nonsense. It's bullshit.
Hey, Matt, I know you know what's going on. We got the writ.
Joe, this is crazy. We just got out of the hospital. Y'all will not stop fucking with me.
You didn't go get your treatment like you're supposed
Bullshit, I did.
No, you didn't.
How?
You didn't call and you scheduled your stuff. Didn't go to the
I
stuff.
did. No, I sent a legal demand letter because it was fraudulent since day one. Everything stemmed from complete lies, perjured lies that came from Joe East. That was proven. Y'all didn't follow, the whole entire proceeding was sham. They didn't follow Mississippi law when it comes to commitment proceedings. They broke federal law. Federal and state law. There was a legal demand sent to Communicare. They had 7 days to respond. I was waiting on a response. They have no right, absolutely no right to do this. This is complete bullshit.
Well, Matt, there's paperwork.
I don't care. This is bullshit. No.
I understand where you're coming from.
No, I'm not. No, I'm not. Nah.
All right.
Fuck no.
All right, let's get him. Come on, put your hands behind your back.
Let me read it. Let me read it first. Let me read it first.
I'll let you read it when we get to the
Let me read it first. Let me read it first before you take me into custody.
I'll let you read it.
All right. Let me end it. Let me end. I can't end it. Baby, come get my phone. Hey, baby, get my phone for me.
You take his phone, so yeah, I got it. I ain't gonna deliver. Promise.
Baby, and let me get my voice recorder out of my pocket. Can I get my voice recorder?
Which pocket?
I don't want that going to the jail. Baby, can
We
you
don't
come?
want, we don't want it in the jail.
Can you get everything? Can you call an attorney too?
Yeah, why are there so many cops here?
I don't know. They're waking up the dogs. They're fucking.
No.
We just heard him hollering on the radio.
Oh
and
my
that's
gosh. Okay.
that's why.
I'm just curious.
This is bullshit.
Hang on. Ooh. Is that everything?
Man, fuck Joe East.
Stop, Matt. God.
No, this is
you
bullshit.
Mike, you got a right to your opinions, and you got.
Goddamn right.
Where's your phone at?
Right here. You got the voice recorder?
I know. Oh, yeah, I do. Yeah, I do. I'm sorry.
Just on.
I can't.
Here you go.